Good day. I want to talk with you now about witnesses. Witnesses who testify at trial within the state of Florida, and I want to identify for you some specific sections of the Florida Evidentiary Code and how they deal with witnesses. We begin with the idea of competency. And what do I mean by that? Competency is the ability of a witness to testify at trial. Competency is presumed within the state of Florida. A party who wishes to disqualify someone as not being competent must show that they're incapable of expressing themselves in a manner such that they could be understood, either directly or through interpretation, or that they're incapable of understanding the duty of a witness to tell the truth. There is no analogous federal rule. What this means is you have to show an understanding of what occurred, an ability to express what occurred, and a willingness to commit to being truthful when testifying. This rule is relatively broad. It means that children, handicapped individuals, folks of diminished intelligence or diminished communicative ability can nonetheless testify as long as the foundation is properly laid. Now, I deal with competency when I put a witness on the stand. One of the other things that we're concerned with is the source of the knowledge that the witness is testifying from. For all witnesses other than expert witnesses in the state of Florida, we look to personal knowledge. There must be personal knowledge on the part of the witness testifying in order for their testimony to be relevant. And a lack of personal knowledge can render them unable to testify. This is exactly the same as the federal rule requirement for personal knowledge, and you can find it in the Florida Code under 90.604 or the personal knowledge rule for the federal rules of evidence. Florida also requires oath or affirmation. Both Florida and the federal rules set forth a general rule that every witness must declare by oath or affirmation that they will testify truthfully. And it's slightly different because Florida specifies the form of the oath, while the federal rules only require that the oath be in a form that is calculated to awaken the witness's conscience and impress the witness's mind with the duty to be truthful. Interestingly enough, child witnesses in the state of Florida do not have to take the oath before they testify. Interpreters, on the other hand, are different. In the federal rules, it's extremely simple. Florida lays out extremely detailed rules governing both interpreters and translators. Florida requires them to take an oath, to interpret truthfully, and to provide a true translation. If you'll think about it for a moment, that makes sense. Florida is a jurisdiction that deals with multiple languages on a daily basis, and the need to clearly define procedurally for interpreters and translators what they are or are not required to do before the court will accept their testimony. It's just part of the cost of doing business in a multilingual state. Let's talk about judges and jurors for a moment and their testimony at trial. In the federal system, a judge will never take the stand. For a judge to be called as a witness, even in a procedural or non-specific matter to the case, would result in their recusal from the case and their removal. Trial judges can testify in the state of Florida on purely formal matters. And that's different from the federal system. Jurors are not competent to testify by operation of law in any trial where they are sitting as a juror. Now, if we have a post-trial motion concerning the verdict or the indictment, a juror may not testify about the internal deliberations, but may testify about any attempts to improperly influence the decision of the juror. So you can look at bias or motive to lie or threats that may have come up in the jury deliberation process, but you cannot look at the deliberation process itself. And that's a continuing example of our commitment to protect the jury process and to keep safe, almost sacred, if you will, the finality of the decision of the jury. And you see this again and again in Anglo-American jurisprudence, a preference for the finality of the jury verdict and a real reticence to inquire into the deliberative process of the jury. Let's move on now and talk about impeachment under the Florida Evidentiary Code and the Federal Evidentiary Code. And we'll begin by making certain that we understand that impeachment is possible by any party of any witness. You do not vouch for your witnesses in the state of Florida, and if you put a witness on the stand and the witness goes south on you, or the witness has both positive and negative information, you have the ability to impeach or attack that witness even when you call them. It could be because they're inconsistent, it could be to show bias, character, defects in capacity, or proof of contradiction. The federal rules of evidence do not specify how to impeach, but if you go and look at the application of the federal rules, they're analogous to what I have here on the slide for the Florida rules. Now, let's say I'm talking to a witness and I'm questioning them, I'm impeaching them on a non-specific matter of the case, what we would often refer to as a collateral matter. It's not tied directly to the cause of action, normally having something to do with the character of the witness. And the witness lies. In the state of Florida, just as in the federal system, you are bound by the answer of the witness. You cannot present extrinsic evidence to prove the lie about the collateral matter. You have to eat the answer. And that's the same in both jurisdictions. It is a little bit different in the state of Florida because if you're the adverse party, and I've had a witness testify on direct examination, providing evidence against me, I do have the ability to admit substantive evidence to contradict what they've said. But if I've asked the question, I have to live with the answer. Let's talk about the character and conduct of a witness in the Florida Evidentiary Code. Florida allows for an attack of any witness by reputation evidence, not opinion. The attack has to deal with their character for truthfulness. And their character for truthfulness is put at issue when they testify at trial. So in other words, in the state of Florida, once someone takes a stand, I can call a subsequent witness to show that this person has a reputation for being untruthful. I can't call a witness to show that they have a reputation for being truthful until their reputation has been attacked. No, then I could in rebuttal. This is different from the federal rules because the federal rules allow for the admissibility of evidence in both the reputation and opinion format. And they also allow for it on cross-examination with specific instances of conduct. We can't do that in the state of Florida unless the specific instances of conduct in question ultimately ended in a criminal conviction for the witness. So if you'll think about it practically speaking, here in the state of Florida, when I'm dealing with impeaching a witness as to their truthfulness, I am stuck with their reputation, and I don't have available to me the other means like I do in the federal system. That's a limitation that is unique to the state of Florida as opposed to the federal rules of evidence. Now, when I go to impeach someone for a prior crime, in the state of Florida, I can attack the credibility of a witness by showing that they have a prior conviction. If the conviction was for a crime punishable by death or imprisonment in excess of 1 year, or if the crime involved dishonesty or false statement, regardless of the punishment. That's the general rule. Now, in the federal system, I can ask questions about the nature of the crime for which they were convicted. In the state of Florida, I am not allowed to inquire about the specific crime, just that they're convicted. If the witness refuses to agree, I then have the ability in Florida to admit the conviction showing the crime for which they were convicted. But before that, evidence of any such conviction is not going to be admissible We don't let it in civil trials if it's not going to bear on the character of the witness. Usually we look at remoteness of time. Remoteness of time will not preclude admissibility in a criminal proceeding, but it is still subject to the 403 balancing test. And of course, in the state of Florida, we specifically accept out judicial adjudications, and we're not going to let those in. We're not going to allow you to use the fact that someone was convicted of a crime as a juvenile in order to attack their credibility. I think it's sort of predicated on the idea that most teenagers are lying when their lips are moving. Their brains aren't fully formed, and we're not going to hold them accountable at the same level when they're testifying as an adult later on. Let's look now at the opinion testimony of lay witnesses and talk about lay witnesses as opposed to expert witnesses. A lay witness is someone who is talking about something that they've perceived. And while there is a preference for the lay witness to talk in terms of facts, of things that were initially observed, we allow for the use of inference and opinion in those cases where the witness cannot, with equal accuracy and adequacy, communicate what they saw without testifying in terms of inferences or opinions. And the use of those inferences or opinions will not mislead the trier of fact or prejudice the jury. And the opinions and inferences involved do not require a special knowledge, skill, experience, or training. Well, where does that really apply? Well, think about it for a moment. You got a guy who's been driving all his life. He's standing on a corner, and a car goes whizzing by, weaving in and out of traffic, and then hits someone. Now, one way in which that individual could testify, you could say, well, I observed the car traveling at a rate of speed in excess of the speed limit in comparison to the cars that were around him. I saw him move to the right, and then he moved to the left, and then he moved back to the right in what appeared to be a jerking, quickly fashion. Ultimately, I observed his vehicle impact the body of the decedent. That's one way that you might have a lay witness testify about that issue. In the state of Florida, an inference or opinion might be much more likely. Sir, please describe for us the way in which you saw the defendant driving his car on the day in question. Well, he was weaving in and out of traffic like a madman. He was going a lot faster than everybody else. And all of a sudden, without any warning, he just ran this lady over. Now, there are some inferences and opinions that are contained within that second version, but it's also a much more accurate version of the way that folks normally talk and the way in the shorthand, the way in which the mind usually works. As long as that shorthand is not going to mislead the jury, we allow it in the state of Florida. Now, that's different from the federal rule for lay opinions, because the federal rule for lay opinions talks about being rationally based on the perception of the witness, helpful to a clear understanding of the witness's testimony or the determination of a fact and issue, and not based on scientific, technical, or other specialized knowledge. So you can see the breakdown here, and you can see the juxtaposition of the federal lay witness opinion with the federal expert witness opinion, and we don't see that in the Florida rule. There's more leeway in the state of Florida for lay witness opinion than there is in the federal rule, and I think that's just an acknowledgement of the way people actually think and the way people actually talk. Okay, well that ends this piece of instruction talking about witnesses generally and the ways in which they testify in the state of Florida. The next time we come together, we'll have a conversation about exhibits and the admissibility of evidence at trial.